National Desk, Claire McKenzie, Northern Canadian Media. Ontario judge rules mandatory minimum sentence unconstitutional in incest case involving offender with intellectual disability. Ontario. An Ontario Superior Court judge has sentenced a sentence of house arrest after finding that the mandatory minimum 5-year prison sentence for incest involving a person under the age of 16 would be unconstitutional in his specific case. The man, identified in court documents only as DC, was convicted of 2 counts of incest and 1 count of sexual assault. The offenses occurred over a 4-year period beginning when his biological sister was 12 years old. During the trial, expert testimony presented by the defense stated that DC has an intellectual disability with cognitive functioning comparable to that of a child between 9 and 12 years old. In her ruling, Justice Malloy determined that imposing the mandatory minimum 5-year penitentiary sentence would amount to cruel and unusual punishment under the circumstances. The court instead imposed a conditional sentence of 2 years less a day to be served in the community under strict conditions, followed by 3 years of probation. In the written decision, Justice Malloy stated that while a 5-year prison sentence is severe for any first-time offender, it becomes cruel and unusual when applied to an individual with a significant developmental disability. Legal experts note that it is uncommon for Canadian courts to strike down or decline to apply mandatory minimum sentences. Judges only do so in exceptional cases where a sentence is found to violate the Canadian Charter of Rights and Freedoms. The ruling has sparked discussion about the balance between protecting victims, ensuring accountability for offenders, and upholding constitutional sentencing standards when significant intellectual disabilities are involved. This case remains subject to a publication ban protecting the identity of the victim.